criminal court. And I can tell you 90% of the persons that appeared were young men. And a lot of it, I would say, is lack of opportunity. Of course, we know that there are a lot of women raising sons. And so there's gang influence. And so there are other issues. And so the declaration is saying there's just not one thing. There's several things. There's social, there's legal, there's economic issues. And so that is really what the declaration is about. And declaration is about saying it's a puzzle. So the court has to take their part. So what is the court going to do? So the court has decided, okay, we're going to have criminal procedure rules, which we just put in force in 2025. We're going to look at judge-alone trials in 2025, like in Guyana, for example. Guyana has judge-alone trials. Now, it's usually frowned upon here because everybody thinks that they want their day in court before 12 men and women. But if we are honest about it, a large percentage of matters are heard in the magistrate court before a magistrate, a single magistrate. So it's what is the difference really? Now maybe the offense may be facing more jail time, but the only point I'm making is that the judge-alone trials would free up would sort of it is hoped that the objective of that is to give the accused person an opportunity to elect, to say, yeah, I would rather go to a judge-alone trial than to wait 10, 15 years to have this case hanging over me and get this matter dealt with. And, the jury system also has issues because a lot of people don't want to sit on the jury, let's be honest, So the declaration, like I said, is really just a way of being a holistic approach to this issue of tackling the issue of crime, which everybody in the Caribbean is facing the very same issue. And so it's just looking at it from the various parts. The court has a role to play. What can the court do? What does the executive need to do? And again, the court is the last road that you walk. When things of society or the community in which you live has let you down, you don't have an opportunity. When you have the gang influence and you don't have anything to steer you in a positive direction, where do you end up before the courts?
And speaking of the court being the end of the line, do you think that when we hear of crime, right, a crime may occur, they said, oh, well, the police need to catch them. The police they're caught by the police, they have a trial, they may not get convicted. And people say, well, why didn't they get convicted? Do you think the court takes a lot of the burden without people considering sitting in court to go and listen to what was brought before the jury, the judge?
That's a lot of it. I think, regrettably, because we are not able to speak for ourselves. We're judges, and so this ability to speak to some of the complaints or the negative observations that are made about, for example, plea agreements and all those kinds of things. The way the jury has decided, the jury is the finder of fact. The judge, when you sit in the criminal court, you deal with the law. You direct the jury on the law. The jury will decide whether they believe that Joe Brown, broke into that house based on that evidence. And so, we as judges are left to sentence after the jury has made their decision. And I think sometimes the public don't really understand that. And it is an unfortunate thing, but maybe more public education to make people aware. The reality is, sometimes cases take long to come to court, and so victims are no longer interested in pursuing the matter. That's one of the problems that we have. So hopefully with the judge-alone trials, that may create an avenue for matters to be heard sooner rather than later. Plea agreements in particular, I think, is a very... I should say a topical issue, but we have a lot of public outcry about the sentences. But you take your chance sometimes in going to a jury. You do not know what's going to happen. The witnesses may not show up. So if you have a plea agreement, then at least that case has been resolved, and maybe the public is not happy with it. But unfortunately, we cannot take every single case to court. It is not possible. We will always have a backlog if we have to take every single case to court.
Definitely. And so back to the Needham's ruling or agreement, some of the other areas addressed in the point, the declaration, crime as a public health issue, reframing crime as a public health emergency. If a crime is declared a public health issue, does that affect the way courts and the judicial system approach it?
Well, I think that it wasn't just necessarily aimed at the courts per se, but obviously the court plays a role. I think calling it a public health, what is the term they use? Public health emergency. Right. The reason for that is because I think that for too long we talk about crime, but we're not treating it with the sense of priority and urgency and importance that it requires, as we did with COVID-19, which was a public health emergency. What did we do? We threw everything we had at it. Okay, we had the cars going around to make sure nobody, nobody was out when they shouldn't have been out. We had the free clinics, so if the free places where you could take the COVID-19 test. We had all kinds of checks and balances. So all we're saying is throw that kind of weight behind eradication of crime and treat it with the sense of urgency that you would treat a public health crisis as we did in COVID-19. So for the courts, like I said, what that means for us are the things we spoke about before, the judge-only trials, the ability to say just how you choose. When you go to the magistrate court, it's only one magistrate sitting. What's different between that and in the Supreme Court? Some of the offenses may be a more harsh or serious sentence. Okay, maybe those for murder, perhaps, but some of the other offenses, such as assault and similar ones, they can be heard by a judge alone. And so again, that would eradicate some of the backlog. Why? Because when you have to get a jury trial, that's a lot. It's a lot of resources behind jury trials, a lot of time and a lot of effort, and because of that, you experience a lot of delays. Yeah.
I definitely think that we are a reactionary society. I can't tell you how many times some kind of crime has happened that's made the nation say, oh my God, how could this happen? And then we kind of go back to our lives, and when it makes its way to the court, we say, well, we didn't check. We didn't say, hey, well, what's the update on this, or how's it going? But when we hear that ruling come and it isn't what we want to hear, all of a sudden it's outrage again. We need this, we need that, we need this. But we never get down to actually taking action. We have outrage, but is there actually action?
I think the other aspect of it that I would say, though, Jasmine, is that for a lot of the offenses, well, first of all, I think the public thinks that jail is the answer to everything. So that's the first thing. I'm not disagreeing, but at the same time, a lot of the sentences or the offenses committed, persons will be coming out of jail at some point, and the rate of recidivism is very high. So what we do is we put them in jail, we forget about them, we don't think about them, and we don't realize that we're not doing enough to ensure that when they come out that they can be contributing members of society. Obviously if more than likely if you're convicted of murder, you probably will spend a very, very long time. But some of the other offenses are predominantly, I wouldn't say a majority, but a high percentage of those offenses, those persons are coming out, and I think we don't pay a lot of attention to how to deal with them when they come out. The accused person or the convicted person. And so I think that's one of the things. We think, oh, well, he gone to jail, that's it, end of story, happy, I'm so happy, So I think it's a holistic approach. That's all we're saying. It has to be holistic. Some are coming out, some may not come out. But for the ones that are coming out, do we have a program? Do we have a way to reintroduce them into society? What are we doing when they're behind bars? It's overcrowded. The conditions are not the best. So what do we do? So we just focus on locking them up and throwing away the key. Yeah.
Yep, definitely. So the declaration also speaks to institutional strengthening. It calls for investment in police, courts, prisons, ensuring faster case processing and fairer outcomes. How realistic is this for these smaller member states with third world economies? And what is the danger if they do not invest in these institutions?
Well, I think you can answer that question by answering the last one. The danger is where we are now, carnage, right? So I think it's as bad and as blunt as it is to say it is that's where we are. So I think that, again, we are reactionary, and we cannot be reactionary. We have to be proactive. We have to find solutions. Like I told you, the judge alone is one of the things. Yes, we can throw more courts at it, but really and truly, we have to focus on not making sure some of these people don't ever come to court. You know, that's really what it is. I mean, what the court can do is what the court can do. We don't want them to come to court. That's what we don't want. We don't want them there. We want them being meaningful, contributing members of society. We want them to have the opportunities that others have. We want the young men to have opportunities. I saw a lot of young men that were affected by COVID-19 because the schools closed down. And so they were, say, for example, they were in grade 10. By the time as COVID was done, they were supposed to be in grade 12, but they missed 2 years of school. Mm-hmm. That's it. They're done. They aged out. So what do they do? I mean, one, I didn't know, I felt for him. He, you know, and he's now 17, 18. So he missed 2 years of his life because of COVID. So what do we do with that? How do we fix that? You know?
Yeah, definitely. So the modernization of laws, Caribbean nations are urged to update laws to address cybercrime, money laundering, and digital evidence collection. Are we adequately addressing these?
Well, I think that's, I don't know if that's a question for Judiciary, because, I mean, I can comment insofar as Judiciary, we don't make the laws, we apply them. So, you know, but at the same token, as and when we apply them, we would notice that certain things are deficient, and it would be good if we had it. So in a way, we can perhaps, there's a subtle push when we make decisions that suggest that you need to modernize certain areas. So the short answer is, I think there are some. There have been some changes, but again, a lot of these changes, certainly into the Evidence Act, allow for digital and virtual trials and hearings. There have been some changes in that regard, but a lot of them are very new. So it'll take some time to see, but I think the change is on the way, and it's coming.
And so it also talks about comprehensive justice strategies. It advocates for coordinated reforms across law enforcement, courts, and rehabilitation systems to improve efficiency and fairness. You touched on this so much already, but we just want to go back over it. What are the challenges in even meeting that mandate or allowing that to happen?
Well, you know what? I must tell you, I think other than the intentionality in doing it, it's financial. Let's be honest. Financial resources. You know, we're constrained. So I think that's probably one of the biggest difficulties, because we know what we need to do. We know what we should do. We know what we ought to have. But some of these things are, I wouldn't say unreachable, but we can only go so far, is what I'm saying. So we recognize that, but we do what we can with what we have. And I think that as long as we're intentional and we say, okay, this is phase 1, phase 5 would look like this. We have a vision, we have a plan, right? Once we have a vision and we have a plan, then we go stage by stage, right? So this is what we're going to do now. But ultimately, we want to get here. But right now, we can only get here. So whatever is what some people call low-hanging fruit, let's try and deal with those things. Other things may be a little bit of a stretch for us, like you said, because financial resources are tight. And, you know, the government obviously has to do what they have to do, and the courts have to do what they have to do. So we go as fast as we can. We are very happy about the technological advancement, which allows people who are self-represented to file their claims online, right? So we wouldn't have been there some time ago. We would not have been there. You know, that would have been a pipe dream 10 years ago. You know, but we're there now. So I just think it's just a vision for where we see ourselves, and then working towards it.
Okay. And you talked about or mentioned education and how important education is. And I always say to people, I understand not too well, but good enough, the court system, because I covered a lot of court before. But honestly, if I was not a reporter and spending decades of covering court, I would be one of those people out there not very well aware. Do you think, and another thing I notice is people watch American shows, I will say Law and Order, and they think, well, how come this? What would this mean? Like bound over by the peace, restraint versus restraining order, and they just don't understand. So, do you think by now in this 2025 we should have some sort of courses, even if it's in a high school level or upper high school level, to just educate people? Because to be honest, we all have to some way, somehow interact with the court system, whether we get a ticket or
Right.
maybe be charged with something.
Right, right. So we, as you say, just to piggyback there, whether we are unintentionally involved in the court system through a ticket, because you can just be driving somebody's car with a dark tint, and the ticket is going to be in Jasmine Brown's name, not Camille Darvel Gomez, even though it's my car. So you're right. So unintentionally, you will get yourself a ticket. So and you will interface with the court. So you're quite right. But I agree. I think that the Bahamas Judicial Education Institute, which we call the BJEI for short, one of our visions is to do a lot more in terms of public education, because I think it's very important. And I think we wait too late. You know, it's like you say, you need to go into the schools. You know, you need to maybe either write articles, you know, maybe need to publish little snippets, you know, because TikTok is big. So, you know, maybe you need to do something like that and say, you know, if you get stopped, this is what you need to do. You know, and so I think it is very important. And I am a strong proponent of public education, because I think sometimes we are unintentionally involved in something that had we known, we never would have been. You know how many times young men came before me and they would say, I say, well, you know, I look at them and I say, where were you working? They have a relatively good job. They have a family, or they have a child that they're taking care of. And I say, how do you end up here? And they said, you know, bad company, just wrong place, either bad company, wrong place, wrong time, had a little bit too much to drink, and so flew off the handle, overreacted to a situation. And so I think through public education, you really would decrease, and you would have an impact, decrease the amount of times that people are appearing before the courts for things that could be unavoidable had they just known. You
Definitely. I'm a very big proponent of education as
Yeah.
well. And honestly, I wish I had learned some of this stuff in high school as well. Because sometimes, 20 years ago, maybe, not lie, maybe 25 years ago, we were learning American history. And I think taking that out of it and learning more Bahamian
Yeah.
for BGCSE, or even not too deep into law, but some kind of
No,
law.
no.
Yeah,
No,
definitely.
I think a law 101 would be good, you know, in terms of traffic fines, in terms of possession of marijuana on a small quantity, in terms of what does that look like, you know, and anything like that, assault, battery, anything like that. Something that, you know, sometimes these things happen, and to teenagers in particular, sometimes maybe boys more than girls, but could be both of them. And so, you know, if you take a step back and you hear, and even using persons who might have been in trouble before but have now taken the straight path, and have them say, listen, I was that person. You know, I was hot-headed. I didn't listen, you know, and I spent 2 years in the Simpson pen. And so I know what it's like. I know what you know, the kind of challenges and the influences and the peer pressure that you're experiencing. But let me tell you, that's not the route to take. That if you take that route, you're going to be off the track for 2 years. You know what I'm saying? Yeah.
Definitely. So I'm going to switch gears a bit and talk about the substantial financial investment and legislative attention given to enhancing the justice sector in the Bahamas. We touched on it briefly, the Court Services Bill, the transformative and groundbreaking legislation that has sought to legislate the financial and administrative independence of the judiciary. I know this was talked about for years.
Yes.
Multiple chief justices.
Yep.
And it's here now, or it's been enacted. How has this impacted the delivery of justice?
Well, you know, I think when I touched on it earlier, I'd indicated it just came into force on the 1st of July. When I joined the Judiciary in 2011, Sir Michael, then Chief Justice, I had seen a copy of the bill at that time. It came up when Sir Brian Murray was Chief Justice. I was then the registrar. And now it's been brought over the finish line by this Chief Justice, Sir Ian Winder. And it's been a long time coming. But again, like I said, it's early days, but the vision and the objective of what it's to do, or what it's all about, is really going to be transformative, but we won't see that right now. Right now, we're going through the growing pains of the registrar doesn't do basically the registrar held the court together. The registrar was, and most people don't know who registrars are. So, the registrars are in the Supreme Court, and they would tasked with running the courts, all of them, magistrate and Supreme Court, and then their registrars in the Court of Appeal, and they did the same thing. So now that we have, and let's bear in mind, registrars are lawyers, so they're legally trained, but they're running courts, So now we have somebody tasked with their primary sole focus is to run the court like a business, okay? And so with all the efficiencies and the ability to pivot when situations and circumstances arise, which we did not have before. So the possibilities are endless, but like I said, it just came into force, and so we're just getting where we need to get to see the actual impact. But we're very grateful for it, and it will definitely allow us to reach the archipelago in a better way than we did before, because we would have the funds to do so.
Okay. Yeah. And it increases the jurisdiction of the magistrate court from $5,000 to $20,000. What does this mean for the ability of the magistrates courts to operate and hear cases?
Okay, so the court services bill didn't do that. That came with that was a magistrates court amendment act,
okay.
Right? That was one of them in the magistrate court, but it ties in. But what is so great about this amendment is that I think the Magistrate Court Act has been in before this amendment that dealt with the jurisdiction about 20 years. So you can imagine 20 years ago, $5,000 was a lot of money. 20 years now, it isn't, right?
Yeah.
So a lot of those cases, regrettably, a lot of court users or litigants who had claims that were in excess of $5,000, sometimes what they would do, they would abandon parts of their claim to get under the $5,000. Or they would try to split the claim into two. So they had to be ingenious to get it done, because why? This increase really is just a broad heading called access to justice. That's all this is about, access to justice. Why? Because the majority of the claims that are heard in the magistrate court are heard by self-represented litigants. So now that you've increased it, the jurisdiction, it means that they can go there. So if they had a claim, for example, an arrears of rent for $10,000, which can run up quite quickly if somebody hasn't paid over years, but they would have to engage a lawyer. And so by the time as they think about that, or they would try to do the claim on their own, but usually procedurally they don't know the procedures in the Supreme Court, and so somewhere along the line they're going to get shut down and they're not going to be able to continue. So this allows them the latitude to bring those claims in the magistrate courts, where there is more user-friendly and they are able to represent themselves. So it's an access to justice point. Greater access.
You're watching RTV's live coverage of the Caribbean Conference of Chief Justices and Judicial Leaders. And just a few seconds ago, across your screens, you saw Attorney General Ryan Pinder, KC, walk into the room, and that should signal we're actually starting soon. We're still awaiting the Prime Minister, and he should be in here very soon to start this opening ceremony. But back to our conversation. It was going so well. The criminal justice reform, amendments to increase the number of Supreme Court judges, amendments to the Bail Act to permit the court to give direction to standardized bail conditions, as well as legislation to permit bench or judge-alone trials. We talked about that as well. New criminal case management rules, increases in fees paid to lawyers engaging in legal and aid work, as well as independent commission for investigation legislation. How have these actions, and some of those that I've not even listed, individually and collectively help to advance the work of the courts and their ability to administer justice to residents?
Again, I think it's it's a little bit of a carry-on or a continuation of what we spoke about before. Trying to reduce backlog, because again, you're talking about judge-alone trials in the Supreme Court, which we already have in the magistrate court. So that's a no-brainer. The public understands that. So that will certainly reduce it, because every time you have to convene a jury, you have a jury of 12 people. If someone can't come this day, you have to adjourn. It's a lot of adjournments. So you reduce backlog when only a judge is hearing the matter, as you do in the magistrate court. The upgrades, of course, we have the new family court complex on Burnett Road, which we're very proud of, and that's been a long time coming. And that was fashioned after the family court in Trinidad and Tobago. They were sort of very revolutionary in their time in having a family court. They have a nursery, they have mediation rooms, they have the police there. I mean, it's a wonderful, wonderful place. I visited it twice, actually, with Sir Michael and then with Sir Brian. And then Ian Winder was able, like I said, to bring everything across the finish line. So as you can see, these things take time, but we do get there. But the vision was always there, because there are a lot of family matters. And what that did, of course, is put all the family courts together, because sometimes you may be in the magistrate court in one aspect of your matter, but you may be getting a divorce, and that's also in the family court in the Supreme Court. But you may have other issues that you're dealing with at the magistrate court level. So all the courts are in one place, and so again, greater access, greater ability to have everything done in one place. There's a nursery going into that court. So those upgrades are really what's going to make us more, give greater access, and also bring the court to the users, bring it to the users.
Yeah. And welcome to the Conference of Caribbean Chief Justices and Heads of Judiciary. My name is Jerome Sawyer. I'm listed in your program as the chairperson, but I will respectfully take the role as moderator today. Please stand as we welcome into the room the Prime Minister of the Commonwealth of the Bahamas, the Honourable Philip Davis. I ask that you remain standing now for the entrance of the Governor-General, Her Excellency Dame Cynthia Pratt. Again, welcome. Ladies and gentlemen, please remain standing now as we welcome into the room the entrance of the flags of nations represented here tonight and the accompanying Chief Justices.
Ladies and gentlemen, we welcome our visiting justices and their flag bearers from the Royal Bahamas Defense Force. The Honorable Justice Leslie Hayes, K.A., Chief Justice of the Republic of Barbados. The Honorable Justice Louise E. Blenman, Chief Justice of the Senior Courts of Belize. The Honorable Justice Larry Musenden, Chief Justice of Bermuda.
You're watching RTV's live coverage of the Conference of the Caribbean Chief Justice and Heads of the Judiciary. As you can see on your screens right now, we are
the Honorable
about to see the
Justice
Chief
Margaret
Justices
Ramsey
from across the
Hale,
region
Chief
enter
Justice
the room,
of the
as
Cayman
well as
Islands.
the flags representing each country. We'll take it to the floor for our live coverage.
The Honorable Justice Yonette Cummings Edwards, OR-CCH, Acting Chancellor of the Corporate Republic of Guyana. The Honorable Justice Brian Sykes, OJ-CD, Chief Justice of Jamaica. The Honorable Dinaz Suratan, Senior Judge of the High Court of the Republic of Suriname. The Honorable Justice Ivor Archie, ORTT, Chief Justice of the Republic of Trinidad and Tobago. The Organization of the Eastern Caribbean's flag. The Honorable Justice Mabel Eigerman, Chief Justice of the Turks and Caicos Islands. The Honorable Justice Winston Anderson, President-Designate of the Caribbean Court of Justice. The Honorable Winston Anderson, President-Designate of the Caribbean Court of Justice. The Honorable Sir Ian Ricardo Winder, KT, Chief Justice of the Commonwealth of the Bahamas.
Ladies and gentlemen, I beg your indulgence a bit longer. I ask that you remain standing for the prayer led by Reverend L.R. Carla Culmer.
Let us pray. We give you thanks, O God, for the conference of the Chief Justices and heads of the Judiciary from around our Caribbean area. We pray, O God, that they will be endued with continued wisdom, innovation, discernment, and courage to lead and to develop strategies and systems that will enhance the judicial systems in all our countries represented. We pray that this time of gathering and conference will serve as a catalyst to inspire, uplift, and to give support to each judicial leader. O Lord, may your continued grace and favor fall on all our national leaders, especially this day, our Governor General, Dame Cynthia Pratt, the Honorable Philip Davis, our Prime Minister, our Chief Justice and host, Ian Winder, all members of the judiciary and legal professions in our country and in our sister nations. May they grow from strength to strength in their leadership. And God, we pray your blessings on today's sessions and this whole conference. We offer all these prayers and petitions to you in the precious and powerful name of Jesus Christ. Amen.
It is my pleasure to invite you to be seated. Again, ladies and gentlemen, welcome. My job tonight as moderator is to simply guide and direct an esteemed panel of speakers. And so my time with you will be short in that regard. For the first time, though, in nearly 15 years, some of the best and brightest legal minds in our region are gathering in the Bahamas. The Conference of the Caribbean Chief Justices and Heads of Judiciary brings together those who are endowed with the honor of leading judiciaries around the country. This is the third time the Bahamas has held this event, and it is my pleasure to welcome now the host Chief Justice, the Honorable Sir Ian Winder, Chief Justice of the Bahamas, to bring opening and welcoming remarks.
Good evening, everyone. I told the moderator that I thought he was going to set the protocol for me. So let me wing it, I guess. Your Excellency, Dame Cynthia Pratt, Right Honorable Prime Minister, Honorable Attorney General, and any other ministers in the House, the past Chief Justices, President of the Court of Appeal, and judges of the Court of Appeal, judges of the Supreme Court, registrars, magistrates, members of the Industrial Tribunal. I see the President of the Bar, members of the Court Service Council, some former Attorney Generals, some former judges of the Supreme Court and Court of Appeal. I see Diane Stewart. I see Ms. Alison Maynard Gibson, King's Counsel. I see Justice Rhonda Bain. I see Ruth Bodavel. I see members of Judicial and Legal Service Commission, members of the Bar Council, colleagues, friends, everyone. I save the best for last. My distinguished colleagues from the region, Chief Justices of the Caribbean, CARICOM region. So let me begin by thanking the Master of Ceremonies for so ably setting the tone for us. But permit me nonetheless to recognize, as chair of this conference, that I have the honor, responsibility, and pleasure of welcoming you all to this opening ceremony of the Conference of Caribbean Chief Justices and Heads of Judiciary, and to thank you all for taking the time to share this occasion with us. I extend a warm Bahamian welcome to our visiting Chief Justices and heads of Judiciary and to their spouses. As you would have heard from the march-in, we have delegates from the court systems of the Republic of Barbados, Belize, Bermuda, the Cayman Islands, the Cooperative Republic of Guyana, Jamaica, the Republic of Suriname, the Republic of Trinidad and Tobago, the Turks and Caicos Islands, the Caribbean Court of Justice, and of course the Commonwealth of the Bahamas. Not present with us tonight is the Honorable Mabel Adjiman, Chief Justice of the Turks and Caicos Islands, who would have only just arrived on the island a few minutes ago. She will join us in the morning, perhaps in the evening if our flight's on time, to begin the formal sessions. Apologies were received from the Honorable Margaret Price Finley, Acting Chief Justice of the Eastern Caribbean Supreme Court. Acting Chief Justice Price Finley was only recently appointed to the post and unfortunately unable to attend in person. We shall miss her contributions, but will ensure that she is appraised of our deliberations and receives the materials shared at the conference. Let me pause to extend a special welcome to the Honorable Winston Anderson, President-designate of the Caribbean Court of Justice, a first-time attendee to the conference. He is scheduled to be sworn in as the fourth President of the Caribbean Court of Justice on the 6th of July, 2025, in Montego Bay, Jamaica. Justice Anderson, like you, I attended my first conference meeting as a designee 3 years ago, just a few days before I was sworn in as Chief Justice. You will find in this group that every member is willing and eager to assist and share their knowledge and experiences. That has been my experience, both during and between conference meetings. So, Justice Anderson, today I again offer you sincere congratulations and best wishes for a successful tenure as the President of the Caribbean Court of Justice. This year's Heads of Judiciary Conference, being held under the theme Judiciaries in Transition, takes place some 38 years since the first of these such conferences were held in Port of Spain in the Republic of Trinidad and Tobago in 1998. This represents the third time that heads of judiciaries are meeting on our beautiful shores. Meetings were held in 2006 under the chairmanship of Sir Burton Hall and in 2011 under the chairmanship of Sir Michael Barnett. This year's theme builds on the successful conference held last year in Jamaica under the theme Judicial Leadership in an Ever-Changing Environment. We also build on the 2023 meeting in Trinidad and Tobago under the theme Moving Beyond the Familiar, Creating a Judiciary for the Modern World. The objectives of the conference are to be found in the Constitution of the conference, which was adopted at our sixth meeting in Cape Chapel, Belize in 2002. The objectives include to provide a forum for the promotion of fellowship, understanding and functional cooperation for the enhancement of the administration of justice within the jurisdiction of each member state and associate state, to examine judicial problems, whether of a national or regional nature, and to arrive at better solutions to them, to encourage, foster, and promote the development of Caribbean jurisprudence, and to establish links with similar organizations of heads of judiciary in other parts of the world. For public edification, it is important that I take a moment to explain the rationale for our meeting in fulfillment of the objectives of the conference. The administration of justice is a constant work in progress, which benefits from these meetings, allowing us to consult together and address the problems which will arise and to share our collective experiences for the implementation of best practices. The conference agenda reflects the theme, Judiciaries in Transition. Over the next few days, in addition to the business meeting, delegates will hear presentations on judicial leadership, execution of strategic plans, challenges of delayed judgments, drafting an AI policy and guidance for the judiciary, judicial complaints under the constitutional framework of the Caribbean, judicial administration models in the Caribbean, development of curriculums for onboarding of new appointed judicial officers, on development of policies on persons with disabilities, and anonymization of sensitive court proceedings. As you would expect, the sessions are closed to allow for the kind of frank exchanges which will permit more meaningful outcomes. We have assembled a strong faculty made up of local, regional, and international talent to facilitate discussions on these important topics. At the risk of being repetitive, I say again, it goes without saying that the administration of justice is a work in progress, and that our collective efforts are necessary to achieve the success we need. The judiciary, the executive, and the legislature are jointly engaged in the business of governance. Each branch has exclusive functions, and while we are separate, we must work closely with each other to ensure good and effective governance for our people. As heads of judiciaries, we recognize that a fully functioning judicial system is vital to the proper functioning of our countries, as a failing judicial system can have severe consequences affecting its governance, economy, and social stability. Some of these consequences include the erosion of the rule of law, delayed justice, economic decline, loss of investor and business sector confidence, and ultimately the erosion of public trust and confidence. We are all challenged with increased criminal activity in our countries, chronic delays in getting trials heard, delays with delivery of judgments, the slow pace at which criminal trials are concluded, increasing backlogs and lengthy disposition cycles, challenges with offenders who are already admitted to bail, and shortages in lawyers at the criminal bar. I am confident in saying that in the Bahamas, while public criticism by stakeholders abounds, all branches recognize the value of collaboration in advancing the governance of our country. It gives me great satisfaction to be able to say to the public we serve that the relationship between the judiciary and other branches of government are on a firm foundation of mutual trust and respect. The fact that both of you, Honorable Prime Minister and Honorable Attorney General, have taken the time to bring remarks today to this gathering is itself a testament to this fact. As we reach the end of the transition period for the implementation of the Court Services Council, it would be remiss of me not to say something about the independence of judiciary, especially considering events around the world where the independence of the judiciary remains under extreme threat. In the Bahamas, we are proud of our leading efforts to legislate for the independence of the judiciary, to give life to this vital constitutional construct. As judges, our independence in our courtrooms and decision-making has never been in doubt, but financial and administrative independence has historically been tied to executive action. The Court Services Act 2023, which came into effect on the 1st of July 2024, seeks to remediate this and to achieve 4 goals. 1, to enhance the independence of the judiciary by placing the courts under the administration of an autonomous body. 2, to confer the Council with the power to provide the courts with administrative facilities and services necessary for the proper administration of justice. 3, to enable the judiciary to manage its administrative and financial affairs. And 4, to promote transparency, accountability in the administration of justice. Under the Court Services Act, the judiciary now decides on issues of hiring, promotions, and deployment of staff, the creation of posts within the judiciary and qualifications for such posts, salary entitlements, terms and conditions, management of court property, allocation of revenues, and priority of expenditure, all of which, of course, are subject to proper accounting practices, annual reporting, and expenditure in accordance with the Procurement Act and other relevant legislation. The Court Services Act provides a mechanism for the Council to agree a fair budget allocation with the Ministry of Finance. It is a mature executive and Parliament which would devolve financial and administrative power and control to the judiciary, albeit after 50 years of independence. I therefore continue to commend the Right Honourable Prime Minister and the Attorney General for bringing this transformative legislation to life, thereby giving effect to the constitutional mandate of a fair, independent, and impartial court. While the conference agenda is compacted, we have managed to set aside some time for some sightseeing and outdoor activities to afford our guests a taste of these beautiful islands. In closing, please allow me to take a moment to thank all of the hard-working members of the local organizing committee and the Court Services Council who work tirelessly to ensure the success of this conference. I know that I run the risk of leaving people out who may have provided valuable support, so let me begin by thanking all of those who played any role, large or small, in preparing for this conference. But nonetheless, please allow me to express gratitude to Court Service Council Acting CEO Mildred Bodie, Acting Registrar Ronaldo Toot and their teams, Roger Smith, Jeffrey Hepburn, Security Director Stephen Seymour, to Justices Smith, Justice of Appeal Smith, Justice of Appeal Turner, Justices Lewis, Johnson, Darwell, Gomez, and Card Stubbs, who contributed significantly to the conference agenda and other important organizational logistics of the conference. To the exceptional team from the Cabinet Office, led by Janine McCartney, Carolyn Conliffe, and Dorothy Smith, who lent valuable support in all aspects of the planning. I also extend gratitude to our partners in the Ministry of Foreign Affairs, Terry Archer and his team, the Royal Bahamas Police Force, Superintendent Knowles and the SIB team, and of course to the Minister of Finance and the Financial Secretary, who made available the necessary funding for this conference. Finally, let me again thank each of you for taking the time this evening to attend this ceremony. Your presence is an affirmation of the importance of this conference. Thank you.
Ian, thank you very much for your remarks. I do apologize for not setting the protocol prior to you coming here, but I do have to say that you did an excellent job, and were it left up to me to look into the crowd and to welcome folks, you certainly would have issued a bench warrant for me massacring that exercise. I gladly admit that I do not know by face members of the judiciary and those who sit in the courts. I do not spend a lot of time in court. As a matter of fact, the few times I have been to pay my speeding tickets. But I am happy to say, as I see the Commissioner of Police looking on, that I have reformed and been rehabilitated from those younger speeding days. Ladies and gentlemen, as we move along in tonight's program, I do have the honor of introducing a man I do know by name and by face and by profession, as I have had the honor of interviewing him, questioning him, and even grilling him from time to time in this role and others. But certainly tonight my job is very simple, and that is certainly just to introduce him. Please help me in welcoming to the podium now to render remarks the Honorable Ryan Pinder, our Attorney General and Minister of Legal Affairs.
Good evening, and I want to thank the Chief Justice for bringing protocol. I certainly would have missed a whole host of people. Your Excellencies, Honorable Chief Justices, Heads of Judiciary, distinguished delegates, we are privileged to host this distinguished gathering of judicial leaders from across the region. Individuals who carry the immense responsibility of upholding justice, of protecting rights, and ensuring that the rule of law underpins our societies. This conference is extremely important. Its contribution to the administration of justice throughout our region cannot be understated. Judicial systems, we know, throughout our region are experiencing many of the same challenges, and the Chief Justice spoke of some of those challenges that we, as small island countries throughout the region, are experiencing. And we must address these issues. Under our administration, we have been aggressive in our legislative agenda to try to assist with the challenges that the Chief Justice has mentioned. We amended the Magistrates Act to increase the financial thresholds of jurisdiction of a magistrate to hear certain matters and adjust the maximum penalties that could be awarded. The broadening of the jurisdiction of the Magistrates Court is intended to rebalance cases between the Supreme Court and the Magistrates Court to relieve the volume of minor disputes from the calendar of the Supreme Court. As mentioned by the Chief Justice, we passed the Court Services Act, which empowers the Judiciary of the Bahamas to operate autonomously from an administrative point of view and takes away the oversight and a lot of times the bureaucracy that occurred from the central government when it comes to the functions and good governance of the judiciary. It certainly, I think, provides for a more efficient administration and operation of the judiciary. We amended the Supreme Court Act to increase the maximum number of judges in the Supreme Court from 20 to 25. This is a significant amendment, increasing the capacity to conduct trials in the Supreme Court by 25%. We amended the Bail Act. The Chief Justice mentioned challenges with bail and people out on bail. We amended the Bail Act to require an accused who is granted bail to enter into a reconnaissance of bail with conditions to which the grant of bail is subject. The amendment also provides that the breach of any of the conditions contained in the reconnaissance of bail shall result in that bail being void. The legislation provides for 3 conditions mandated to be in the reconnaissance of bail. The accused person shall not commit an offense while on bail, shall not interfere with witnesses, and shall duly appear at the time and place of trial or of an adjourned hearing and not depart the court without leave. Any violation of those mandatory conditions results in bail being void. We passed Anti-Gang Act. Certainly we have an issue throughout the region with violent crimes. We passed the Anti-Gang Act, which makes provision for maintaining public safety and order by discouraging membership in gangs, suppressing and punishing participations of gang members in serious offenses and in gang-related activities. The act makes it unlawful to be a gang leader or a gang member and prescribes the evidence which is admissible to prove membership in a gang. That has always been a challenge. How do you prove membership in a gang? We legislate the foundational elements of how you now approve membership in that gang. We also passed the Trial by Judge Alone Miscellaneous Provisions Act, which grants the right of election to persons charged with indictable offenses in the Supreme Court to be tried by judge alone. The act provides that the accused persons on arraignment in the Supreme Court may waive their right to a jury trial and elect trial by jury alone, but only after they have either sought and received legal advice or waived their right to such advice. We have had an aggressive, tough-on-crime legislative agenda coupled with legislation to enhance the operations of the court systems of our country. That has been a mandate of the Prime Minister. But this is not the end of our legislative agenda when it comes to being tough on crime and when it comes to the administration of justice. We have drafted a new penal code that is going to be soon out for public consultation that is intended to reflect best practices and ensure that it is fit for purpose. Our penal code goes back, I think, to the 1920s here in the country. These will go hand in hand with new sentencing guidelines that Chief Justice is working on that are also being drafted and will be released together. You have a new penal code with new sentencing guidelines to ensure that you have a best practices and fit for purpose comprehensive system when it comes to criminal justice. We drafted a new firearms bill that are in the final stages of being worked on with the police and will soon be out for public consultation. This is an important piece of legislation because the use of firearms and what is a firearm has progressed dramatically from the days of which our firearms legislation has been put in place. It will have much wider coverage of illegal firearms, including gun kits, assembling firearms from gun kits, as well as the production of 3D firearms. We now, I know throughout the region, you're probably struggling with the same thing. You have 3D printed firearms on the streets. The bill will apply specifically to ghost guns. These are inherently dangerous, they're unregulated, they have no manufacturer's name on it, no serial number, and impossible to trace. These are on our streets. We will prohibit the acquisition of high-powered firearms, of assault weapons, submachine guns, machine guns, and the component parts of those firearms. The ammunition for those specific firearms and the accessories that may be used to convert a licensed firearm into what would otherwise be a prohibited firearm. Our firearms bill goes back to the 1960s. It was amended in 2014, I think, but use of firearms and the types of firearms and violent crimes using firearms has progressed dramatically since then. We also believe that the judicial system should have the resources, the technology, and the infrastructure to do their jobs and ensure that justice is preserved. We have supported the digitization of the court system, supporting e-filing of matters which assist in the efficiency of hearings that are being conducted. We have opened a new family court complex to ensure that family matters are heard with the decency and the privacy that is required in family matters. We will soon break ground, Prime Minister and Minister of Finance, on a new Supreme Court judicial complex, hoping to break ground this very calendar year. This will ensure that the judges have the physical infrastructure, the technology, and the modern facilities necessary to adjudicate matters in this era in which we live. I know the Supreme Court judges are very happy to hear that. The new Supreme Court complex will also provide and allow for space necessary to roll out additional specialty courts. You heard that we talked about the family court. We intend on having a sexual offenses court, a juvenile court, a new coroner's court, and a commercial court. A new Supreme Court complex would give us the space to allow us to now develop these specialty courts. We believe that these courts will help with the administration of justice and help with the efficiencies that are required to ensure efficiency in our system. Our government is committed to doing what we can to ensure the effective and the efficient administration of justice. We have asked the judiciary to likewise give the same commitment which is within their remit. This includes ensuring that decisions are rendered in a timely fashion. In the Bahamas, and I would suspect throughout our region, we struggle with justice delayed because of long waits for decisions to be issued. I know our justices are working very hard to reverse this trend that we have had in our jurisdiction. And I trust throughout the region, you're likewise doing the same with your judiciary. We also need to ensure that trials are not unduly delayed. Firm control by the judges over their courtrooms and the attorneys before the courts is a requirement. Our Prime Minister always speaks about when he was in private practice doing criminal trials. A murder trial may have taken weeks to conclude. And now we're talking about trials taking many months to conclude. We must work collectively to shorten the time for trials to be concluded. It is a material factor in the long delays of criminal matters actually getting to court, because a judge can only have so many matters on his calendar. And if those matters extend months and months when they should not extend so often, then the calendar gets backed up, then courts get backed up, then bringing things to court gets backed up, and then you hear the public criticism that the Chief Justice spoke about it's taking years to get this criminal matter to court. We must control our courtrooms. It's very important. We all have a common interest here, all of us, in ensuring that the efficient administration of justice in our countries and throughout the region happens, and it's a reality. This conference allows us to collectively speak to the challenges, opportunities, and improvements that can be had in our judicial system. Ensuring that justice is served effectively and efficiently is not only good order in our societies, but it is vital to the public confidence of our institutions themselves. The last thing we want is our populace having no confidence in our judicial system, having no confidence in our law enforcement system, and having certainly no confidence in our government system to be able to handle these matters. And the effective and efficient administration of justice underpins this confidence. So as you deliberate over the next few days, I encourage you to have a constructive and a thought-provoking conference. Create bonds, certainly relationships, and strategies that will enhance our region. I thank you for the opportunity, Chief Justice, to bring these short remarks. And I invite you to enjoy our beautiful country. The Chief Justice said he has some excursions and other things of leisure planned as well, and I encourage you to take them up. I want to thank you. Again, welcome to the Commonwealth of the Bahamas, and I encourage you to have a great conference. Thank you very much.
To our Attorney General, thank you very much, sir, for those comprehensive remarks. And sounds like we have lots and lots and lots of courts coming. Lots of courts. And so I know that you mentioned the legislation that makes it illegal to be a part of a gang, but having so many courts now, I need to sign up to be in the army of the Lord to ensure that I avoid those courts. Ladies and gentlemen, as we move along in our program, you would have already heard that our guests will have an opportunity to enjoy some of the sights of our beautiful country and get to experience a bit of leisure time. But we wanted to get you started to experience a bit of the culture of the Bahamas. And so we brought out one of our national treasures and decided to put that on display for you. Those of you who are native to the Bahamas know and love this treasure very well. Ladies and gentlemen, it is my honor to introduce now definitely one of our great treasures, the Bahamas National Youth Choir. right, ladies and gentlemen, another round of applause for the Bahamas National Youth Choir. And while they did not have any microphones, if I could step out of character for just 1 second, these Caribbean people by me need no mic. But thank you very much to the Bahamas National Youth Choir for getting our entertainment started this evening, because we do have a bit more for you. But as we move along in the program now, we move to one of the most important parts of the evening, and that is our keynote address. And my job is to simply introduce the individual who you know and have heard from already, who will be coming to introduce our keynote speaker. Ladies and gentlemen, again, help me welcome to the podium our Chief Justice, the Honorable Sir Ian Winder, to come and introduce tonight's keynote speaker.
Good evening again. I'm not sure if the poor Prime Minister has anything left to say after the Attorney General did his mini keynote. But ladies and gentlemen, distinguished guests, it is my distinct honor and privilege to introduce to you a leader whose life and career have been defined by service, resilience, and unwavering commitment to justice and national development. The Right Honorable Philip Edward Brave Davis, King's Counsel, MP, JP, is the 5th Prime Minister of the Commonwealth of the Bahamas, a son of the majestic island of Cat Island, and a proud Bahamian. Prime Minister Davis has dedicated decades to public life. Before entering frontline politics, Philip Davis, then, was a lawyer of considerable repute. From humble beginnings, he rose through the legal profession to become a respected advocate. A former president of the Bar Association, Prime Minister Davis was a member of the Council of Legal Education and served as a member of the committee that produced the seminal Barnett Report. In my view, he remains the foremost authority in the Bahamas on extradition law and election law. As a former magistrate and long-standing member of Parliament, he brings to this forum not only the voice of government, but also the insight of a legal mind shaped by experience and empathy. Please be upstanding and join me in welcoming Prime Minister Philip Davis, the Right Honorable Prime Minister of the Commonwealth of the Bahamas.
Please be seated. It is settings like these, and I look at my so Michael Barner just laughing his head off because he's one of my teasers. Continues to remind me that I may be in the wrong job because I miss the profession so much. And he continues to remind me. And in settings like these, that truly brings me back to what I'm really all about. And that is ensuring that the rule of law continues to underpin what we're all about, not just in the Bahamas, but in the Caribbean and the wider common law jurisdictions. But colleagues and distinguished guests, our Governor General, Most Honorable Cynthia Mother Pratt, to all of my distinguished colleagues in the audience, justices and friends. It's really a pleasure to see so many of our region's sharpest legal minds gathered under one roof. Welcome to the Bahamas, my friends, and I hope we have made you feel at home. And of course, welcome to the 2025 Conference of Chief Justices and Heads of the Judiciaries of the Caribbean. I recall when, I guess it was 35, 38 years ago, when the idea was born. I think it was Chief Justice Telford Georges back then who birthed the idea that we should that chief justices and heads of judiciaries, quite apart from meeting at Council of Legal Education, that they should have their own separate meetings to have exchanges as you would be having here. I think at the same time he was mooting the continuing judicial education concept that most justices at that time resisted. But we are honored to be able to host this important regional forum. As you would have heard, the last time this conference was held here was in 2011, and so it is indeed a pleasure to witness its return. The theme for this year's conference is a timely one: judiciaries in transition. Transition is an appropriate term for the moment in which we find ourselves, with AI and other emerging technologies reshaping the way we deliver justice, and with the demographic shifts and climate change altering the very texture of our societies. Transition is not simply a descriptor for Caribbean judiciaries. It is an imperative. It cannot be business as usual if we endeavor to deliver fair, efficient 21st century justice. Our history is rich, and it is indeed pushing us along. But to keep up with the evolving legal landscapes in which we find ourselves, we must abandon the comforts of existing bureaucracy and embrace transition. Caribbean judiciaries in transition must weigh the costs and benefits, for example, of expanding capacity. In some contexts, the benefits, for example, of a specialized court do not outweigh the costs. But here in the Bahamas, we found that our system would benefit significantly from expanded capacity, both in terms of reduced case backlogs and improved public confidence in the judiciary. And so, as you would have heard from the Attorney General, at the end of last year, we opened a new specialized court for family matters on the island here of New Providence. The family unit is, after all, the bedrock of our societies. Our families take many forms, and they deserve a justice system that responds to their unique, manifold needs. For Bahamian families navigating disputes, custody arrangements, and other complex circumstances, there was a need for expanded court capacity. We recognize that need. Consideration, clarity, and closure is what our people deserve, and so we got to work. We opened the family court complex last December, as you would have heard from our Attorney General, as part of our broader mission to modernize the Bahamian judicial system. Upgrades to existing court campuses in downtown Nassau, including renovations to the main Supreme Court buildings, are also underway, as is the construction of a new mediation court scheduled for completion by the end of this summer. Additional resources are being mobilized to digitalize our court files throughout the judiciary of the Bahamas, with the introduction of electronic filings and integrated case management systems representing further improvements. Criminal justice reform is also a significant facet of our modernization agenda, in line with the Needham's Point Declaration adopted by Caribbean leaders at Bridgetown in October 2023. We have done a number of reforms, as you would have heard earlier from our Attorney General. As we improve our capacity to deliver justice, we nevertheless recognize that, as an archipelago, the issue of access remains a challenge. The Bahamas, of course, is not alone in this regard. Twin island states like Trinidad and Tobago, as well as multi-island states like St. Vincent and the Grenadines and Turks and Caicos, face similar issues of distributing justice to dispersed populations. Here, however, lies our greatest opportunity to transition toward greater judicial access and impact. Digital solutions, such as remote hearings, represent one means of enhancing access to justice by eliminating the financial burden of traveling to urban centers from the Family Islands to Nassau, for example. Mobile justice services, traveling legal clinics, and community legal education programs can empower residents in rural areas to better navigate the legal landscape. At our Bahamas Department of Corrections, for instance, provisions for a virtual court have been made to advance progress on this very front. For the 11 judiciaries represented here today, the innovations adopted to improve the administration of justice will, of course, be influenced by the particularities of local contexts. No matter the tools adopted, we must ensure that in getting ahead of the digital curve, we not leave our elders and other vulnerable citizens behind. Judiciaries in transition must stay tuned to the needs of the most vulnerable to ensure efficiency does not come at the expense of equity. Innovation, education, and access go hand in hand, my friends. That is how justice systems transition justly. Legal judgments do not exist in a vacuum. They profoundly impact the lives of our people. Without fairness, impartiality, and efficiency, our justice systems risk the perceived credibility and its public confidence in the judiciary and the separation of powers, which underpins the stability of our democracies. Recent surveys note a perception of low confidence in Caribbean judicial systems. This perception cannot be disregarded, not least in a season of transition. Public confidence is not a given. It must be nurtured and kept. What an individual believes about their justice system, whether it is open to them, whether it will work for them, whether it can deliver a resolution swiftly and soundly for them, will determine if and how they engage with it. The smallness of our societies, though typically framed as a challenge, is in this case an opportunity. Make the right changes and get the right message out about these changes, and public perception will improve. At its core, increasing public confidence begins with modernizing our systems with the most vulnerable in mind. It means fair compensation for public defenders. It means safeguarding anonymity in sensitive cases. It means swift justice. And it means developing a watertight AI policy and embracing digital solutions that expand access to justice. A just future for Caribbean judiciaries will depend on our capacity to transition justly from the bottom up. Right here, right now, we have an opportunity to define the trajectory of that transition. Let's do it with a clear moral vision of a justice system that is accessible and trusted by everyone. My friends, may you have a fruitful and exciting conference, and may the conversations you have in the days ahead shape our judicial systems for the better. I want to thank each and every one of you for participating, and may God bless all of you. Thank you.
Ladies and gentlemen, a round of applause again for our esteemed Prime Minister, the Honourable Philip Davis. Thank you very much, sir, for your remarks. You certainly have issued a clarion call and a call to order and a call to action to all assembled here. Thank you so very much for your opening remarks. As we move now towards the latter part of our program this evening, we certainly could not leave you, especially our visitors, without an indigenous taste of the Bahamas. So you got a bit of our treasure, but now we are going to take you to a place and a space that is truly Bahamian. The cultural icons will say that it originated in the home of the Prime Minister in Cat Island. There are others who would dispute that, but in this setting, I'm going to go with the Prime Minister's Island, Cat Island. So, ladies and gentlemen, those of you who are familiar, well, you know what to do. And those of you who are visiting, I invite you to take in the indigenous sounds of the Bahamas. Rhythm and youth, we call it rake and scrape. So they are a rake and scrape band. Please help me welcome this very talented group of young people. Rhythm and youth, our rake and scrape band. right, let's give them another round of applause. What a magnificent display of talent, the immense talent that we have in our country and in our region. I know many of you were thinking the same thing that I was thinking as I sat there. If I did not have on this suit, and if I was not in this place, in this setting, this was going to be a very different age.
You're watching live coverage, RTV's live coverage of the Conference of Caribbean Chief Justices and Heads of the Judiciary. I'm your host, Jasmine Brown, here with my co-host, Supreme Court Justice Camille Darville Gomez. And the program is still going on behind us, but I just want to talk about what we've seen over the past 45 minutes. We had a lot of huge speakers. We had the Chief Justice, Sir Ian Winder. We had Attorney General Ryan Pinder, as well as the Prime Minister of the Commonwealth of the Bahamas. A few things stuck out to me based on what they said. The Chief Justice obviously reiterated what this conference is about and some of the objectives. The Attorney General, Ryan Pinder, talked about amendments to the penal code, as well as new sentencing guidelines and breaking ground for a new Supreme Court building this year. Anything stood out to you that you heard tonight?
Similarly, the Chief Justice's speech talking about, as you said, what's going to happen, the opportunity for the heads to collaborate, to share, to be exposed to new ideas. In particular, he talked about the use of AI for the enhancement of the delivery of justice, and that is actually a very hot button topic at this time. So I thought that talk is being done by Sir Geoffrey Voss, the Master of the Rolls in the UK. So, even they're bringing in somebody from the international arena who has experience with dealing with this. The Caribbean Court of Justice similarly is going to be talking about that. So he talked a little bit about that. The AG himself talking about some of the things we had already talked about in terms of the Needham's Declaration, and he was talking about the pieces of legislation that they have enacted to facilitate the puzzle that we talked about. The declaration was a holistic approach, and he talked about the parts or the role that they have played in bringing legislation forth to make that whole declaration, from the executive point of view, doing their part to make that a reality, meaning to make that the whole criminal justice system reformed and all those things. And then the Prime Minister really just brought everyone together. He talked about the transition, the time that we're in, and he too talks a great deal about AI and the use of AI. So I thought that the three of them sort of put it all together, and we've discussed a lot of what they were talking about earlier in the segment. And so I thought that it was really a good rounding out of what we had spoken about earlier.
And obviously they have a lot to get to, a lot of serious discussions, closed sessions to
Yes.
get to over the next few days. This is just the opening ceremony.
Exactly.
The real work begins tomorrow. But I did hear somebody mention there are some planned excursions, so the visiting Chief Justices can obviously see how beautiful our country is and also
Yes.
get to experience the Bahamas.
Yes, they do have quite a few excursions planned. I think it's a sail away on Saturday and some tours, the straw market, the world famous straw market. So yes, we do. We did try to give them some exposure and get them out, notwithstanding they're here on business. But by all means, yes. So yeah.
Sounds great. Sounds like they're going to have some discussions as well as have some fun.
Exactly.
And obviously, it was great to have you here as my
Thank you.
co-host this
Thank you.
evening. I've interviewed you before, many times before, but now I can say you've co-hosted with me, and it was obviously a pleasure.
Yeah.
And I want to thank our viewers for tuning in and sticking with us and watching our live coverage of this event, as well as thank on behalf of the entire news team, as well as our production team and the RTV team. I want to thank everybody for joining us. Good night.
Good night. Thank you.
Encourage you to deliberate and to work hard. We've also encouraged you to play hard. And we're going to set the tone with that tonight. And so you experienced our treasure in the National Youth Choir. You experienced a bit of our indigenous music in the rake and scrape and in the band. But certainly you cannot come to the Bahamas. You cannot mention the Bahamas. You cannot be immersed in the culture of the Bahamas without Junkanoo. And so, ladies and gentlemen, in our final bit of performance tonight, please help me welcome into the room that thing that defines us and makes us different. We are so passionate about, we love, and we can never do without. Please welcome tonight's Junkanoo group, and please feel free to get up and enjoy.